thank you very much, Fred, for the invitation, and I listened with a great interest the previous speakers. Let me, before answering your question, say a few things that I think could probably be contributing to the debate. The first thing is that many people actually usually ask the question, well, can competition law really play any significant role in all this, quest for environmental sustainability? I think it's actually the wrong question. I think we live in a more and more complex system with a lot of interlinkages between various effects. I mean, we are all aware of the butterfly effect. To a certain extent, even small changes can make a significant difference. But that said, I think we need to be a little bit cautious in terms of, what can competition do for climate change in the context of, for instance, a national competition authority might not be the same than, for instance, looking to other types of pollution coming out of more local level that could probably be of interest for competition authorities. The second thing is the role of regulation. I mean, people say, well, we can achieve the same objectives and probably better with regulation or subsidies. The question there is that not all countries can do that. There might be a funding gap, a significant funding gap in particular countries that have been in economic crisis for many decades, and a regulatory gap in sense of expertise and possibly having even a good regulation. So, and also, let's not forget that EU competition law applies also to regulation. And regulation in this area tends not to be the kind of command and control regulation we think about. It's basically incentive regulation. It's based on sometimes self-regulation initiatives to which competition law, EU competition law, may apply. So from that perspective, we need somehow to make sure that we provide the right guidance, not only for firms, but also for states, where we can obviously apply jointly Articles 4.3 of the TEU with Article 101 and 102. Now, coming a little bit to the differences, we are very much aligned with the Dutch Competition Authority. That's also why we commissioned this joint report. I would say that possibly we emphasize more the question about the concept of user in the context of Article 101, paragraph 3. We heard before that the way this article is written, in particular this focus on fair share, means that efficiencies, at least the current definition of that, the mainstream view, is that efficiencies generated by the restrictive agreement must be sufficient to outweigh the anti-competitive effects produced by the agreement. It's kind of a demand for full compensation. And secondly, that the group of users affected by the restriction and the group benefiting from the efficiency gains should at least overlap. So should not necessarily be substantially the same, but at least overlap. We actually a little bit take issue with this concept of user, and usually what we think, we equate that usually with the concept of consumer, but we actually think this is the wrong approach. Concept of user is broader and enables us to not to take this representative agent theory model for consumer welfare that we usually rely upon, where actually revealed preferences approaches, preferences are revealed through choices in the marketplace. What we actually say is that preferences may also be revealed in other contexts where these users, A, B, C, and D, are basically acting, probably the policy space, probably in their nature as citizens, right? So from our perspective, the fact that there is in our legislation and in some countries there in our constitutions provisions concerning this integration clauses, provisions concerning the protection of the environment, show that there's a preference, a stated preference of the users in their dimension as citizens in favor of this environmental sustainability. And I think this really breaks with the somehow assumption that, well, if consumers do not really probably value that much environmental sustainability, there might be an issue there. Well, what we actually say, well, what we need to focus on is also the fact that we are trying to transform the preferences of the users to a certain extent through this normative intervention by, for instance, putting forward environmental objectives and principles. And in a way, we have in our environmental regulation the concept of polluter pays, which I think should have some significance in this context. And by having this broader approach of users, I do not think we risk very much. I don't think we should worry from a competition law perspective, because if we look to Article 101, Paragraph 3, we have two other conditions that may somehow check a possible expansion of benefits, for instance, by the condition concerning that agreements should be no more restrictive than necessary, and also that there should be no elimination of competition in the relevant marketplace. So from my perspective, what we need to do, and I'm passing what I had to say about Article 102 and merger control, and maybe we can come back later, is that what we need to do in terms of understanding how to go forward is to address a little bit the type of trade-offs that we need to figure out, and also in particular the evaluation question. So in the study that we commissioned with the Dutch Competition Authority, what we try to do is to look at different approaches. So we first take the more mainstream consumer micro level, and we are basically trying to look to if consumer it's a willingness to pay or willingness to accept methods, and that have been used also in environmental economics within either revealed or stated preferences approaches, and how actually these could possibly deal with problems such as the one on free riding. For instance, consumers have a high willingness to pay for the sustainable product, but prefer others to pay for the CO2 and NOx emission reductions, or prospective changes from future generations of consumers may have a higher willingness to pay than present generations, or behavioral economic problems, the internalities that Maurice discussed before. Willingness to pay of consumers may be higher if they have an assurance that others contribute as well. And then we open this up to the next level. Let's take the macro perspective of citizens. The part of this part of benefits of the above sustainability agreements, for instance, the positive effects of reduced CO2, go to consumers as well as non-consumers, together labeled as citizens. The benefits of citizens in the country of emission reductions may be measured in monetary terms using shadow pricing. And basically, the idea would be to understand what are the standard methods that exist to estimate shadow pricing, including the damage cost and abatement cost methods. And how can shadow prices be used to quantify sustainability benefits in a way that they can be compared to the price increase due to the agreement. And then, what we like to do in the report is to open up to the exploration of other methods and approaches that possibly will take a broader view of the concept of user than the representative consumer, final or intermediate perspective that we have on a specific relevant market. So what we try to do is to take a more realistic perspective of the interests of the user, take into account the complexity of social interactions and the overlapping games of life to which each of these users participate to. And from that perspective, we would like to first focus on the significance of the broader constitutional context to find evidence of the interests and not necessarily of the willingness to pay of the users. For instance, by taking a prioritarian social welfare function approach, like that put forward in some studies by Bergson and Samuelson, but also applied systematically in cost-benefit analysis. Or try a Rawlsian Maximin perspective, for instance, with the least advantaged group being basically the class category of users with the lowest expectations in terms of benefiting from environmental sustainability. Or taking a thoroughly and functions and capabilities approach, like that's suggested by some from the perspective of Amartya Sen's type of work, and eventually also look to other sources of wisdom about consumer citizen preferences from sociometrics that may have already been incorporated in environmental impact assessment. So I think that's basically the ambition of the report, and we hope it will be completed by February and will provide a first at least first insights on this important issue.